All right. Hey, everybody. Welcome to week bajillion and a half webinar. Gary is having eye surgery today. And we think that he will recover well, but it means that he's not on, which probably means that we'll be done early. unless I stall for time so we can stretch the hours, so then we don't get in trouble with Gary afterwards. But anyway,
And just so you
welcome
know,
to.
I've asked Gary to ask them to actually get it right this time, so that way he doesn't have to go back for a third time. So
Yeah,
hopefully,
no, that'd be good. The recover I don't know what the recovery is on this one. The last time the recovery was miserable. He had to be lying on his stomach, but not like on a pillow to where just looking down for like a week. And I'm just like, I would not that you know, I probably would need to be isolated because nobody would want to talk to me if that were the case. So anyway, welcome everybody. We're going to be talking this week about more stuff that you need to do before the end of the year from a tax and legal perspective. And by more stuff, this isn't like you really ought to have a budget. You really ought to, set your key goals and, put your bonus. This is like, dude, if you don't do this before the end of the year, you can't do it. Because thus far, as far as I'm aware, there's not been a time machine invented that will allow me to go back in time. And at the same time, this is also stuff that I can't make up the dates, with the IRS, and this is also probably what for Jack stuff on the legal side. This isn't one of those, yeah, but if you kind of find a shady attorney, maybe they'll backdate the agreement. Sorry, that was not for the shoemaker compliance people. But it's the stuff like you need to get it done before the end of the year or so. Stop procrastinating, get it done. So we're gonna hit round two of that. Last week we had round one. This will be round two, and Jack and I, since we have short-term memory loss, we will try not to forget what we already covered, and we'll not cover it twice. So anyway, with that in mind, I'm still on the news
well, hold on.
dive.
Let me
Jackson,
if before you go into the substance stuff,
yeah,
two quick updates. So first, most importantly, as I've said before, I'm kind of a student of psychology. When I go to the airport, I watch people, and so I'm also a student of my own psychology. And it's interesting how a certain perception of a certain NFL Super Bowl winning coach can change when he becomes your college's coach. So while I was, all about inflation gate and cheating and everything else, I'm like, yeah, okay, that's when he was a pro coach, and now he's a college coach and he's my coach. So I'm okay with Bill Belichick for now. And but it's very interesting. The whole, Chapel Hill is no different than any other college football program, probably maybe a little less so than like Texas and other Alabama, but the alumni are very harsh on, and I think that well, there's a backstory behind the whole Mac Brown thing, which is very interesting. I was talking to a member of the board of trustees who hangs out with the AD and with the chancellor, and so it's one of those things where maybe what you see in the media is not necessarily accurate as to far as what actually happened in those boardrooms in the chancellor's office. But anyway, tangent aside, happy to have Coach Belichick as a Tar Heel, and I really think that will hopefully make the program better when you might have more wins than losses in a season. So there's that. Secondly, an update on the whole Corporate Transparency Act, beneficial owner information reporting. So as we thought, but now I can tell you definitively that the pause applies to all companies across the board. So it doesn't matter if you were formed prior to January 1 of this year, during this year, starting January 2025, both the requirement to register and the enforcement by the regulatory agency have been stayed. And so there was some question because when they first came out with the injunction, that it only mentioned companies that were required to file by January 2025, meaning the ones that had been formed in 24. I had speculated that it was more clear than that, in that when you put a pause on the US code, the statute, the federal statute, and then you put a pause on the regulation that has all of these timings in there as far as before 24, during 24, during 25, and you say we're pausing everything, that means what it means. And so it would be incongruent for them to enforce one timeline and not the other. So good news that everything is on hold. The fight is not over yet. I don't believe this will go into 2025. There are some lower federal courts. So here's a lesson on, Schoolhouse Rock kind of thing, where if you remember that, okay, when you have federal courts at the trial level, which is the lowest, well, they're magistrates, but then the trial courts, you have, when they have differing opinions, if they're in the same circuit, so there's groupings, regional groupings of federal courts that are appeals courts, and then you have the Supreme Court. So it's three-tiered essentially. There are lower courts that are agreeing that they are saying that it's enforceable. You have lower courts that are saying it is not enforceable. And then you have two different, at least at this point, two different appeals courts that have taken it up and are leaning towards it being unenforceable, including the Texas court and the circuit court that have said pause. And so the logical conclusion and how these things usually go is it will likely go up to the Supreme Court, because you're going to have the next level down, the appellate courts, U.S. Court of Appeals in various districts, saying different things. And so the Supreme Court is usually the arbiter, unless something happens in Congress that overrides that. So talk about, separation of powers. There's a lot of that going on, and actually is the basis of the fact that it was put on hold, because the argument is that the regulatory agency, again, under the executive branch, has done something that they are not permitted to do, because that is up to the legislative branch, Congress. And now you have, this is total civics demonstration, federal governmental law, and you have the judiciary, the third branch, that is going to be the referee in all of this. So anyway, that's the update. So all is good now for pausing. What we are suggesting to our clients is to go ahead and get that stuff ready to go, and you can file it if you wish. And the reality is that if you're a U.S. citizen, the feds already have your passport if you have one. They have your driver's license number and your picture. They have your social security number. They have your blood type. So it's just, it's one of those things that really is inconsequential. But I also know people are very much about maintaining their privacy. Although, once again, I was mentioning a present to my kids for my wife, suggesting them to go buy. Didn't look anything up on it. And then next thing I know, in my feed, there are suggestions of manufacturers who make the product that I had told them over the phone that they should maybe go buy for their mom. So again, someone's always listening. So that's my mini rant for the week.
I would like to clarify a couple things, Jack, about your rant. One is I did look up Schoolhouse Rock, and season 3 appears to be the season that we went over government programs in Schoolhouse Rock. And the way the circuit court system rolls up to the Supreme Court was, in fact, not a Schoolhouse Rock episode.
Oh,
so we did
really?
we do have the episode.
What you're saying is I added value.
Yeah, you added value.
Yeah, good.
Episode 10 in season 3 does cover America Rock, which does explain the 3 branches of government, but I highly doubt that talks about, the poop fest, which is called lower courts disagreeing with each other, blah. So anyway, I appreciate the value add, because I actually didn't know that. So there you go. And then it's funny, with respect, I swear we're going to add value in this conversation in a second. With respect to Bill Belichick, it's funny, the parent board, because my daughter goes to Carolina, so the parent Facebook page is blowing up, over this decision. So I'm really curious to see what happens, because a lot of people did not have the Jack Saniello attitude about this, and it was sort of less the less of the deflate gate, more of the, hey dude, that guy's got like a 24-year-old girlfriend and is not nice to the media. Is he gonna be good to the students? Anyway, so I'm just excited to see how it all turns out. So there you go. But with respect to um crap that I need to get done before the end of the year, we'll go one tax, one legal, if that's all right. So this will give Jack a chance to stall and hit his chat GPT, for advice here. But the on the tax side, this one's gonna sound a little bit like, well, I thought the rules were a little bit different, Adam. And I'm gonna give you the reason why. Um, so one of the ones we hit on last week was, hey, I need to determine what my pay is going to be, as an owner. Um, and that made sense because what I pay myself can impact my taxes. Well, related to that, I need to decide what I'm going to fund for my retirement and what I'm willing to fund for my employees' retirement. And where that throws a lot of people off is that, if they go to their 401k provider and say, hey, what can I do? They say, well, wait till after the end of the year after you pay people, we can tell you what you can do. Well, the problem with that line of reasoning is that, well, first off, that's just the retirement planners being lazy. The problem with that line of reasoning is that if I knew that I could do more, I would have paid myself more. So the pay determines the amount that I can do. Therefore, I need to back into my pay based on what I want to do, not the other way around. And the same thing applies to bonuses, right? So like if I say, you know, I'd like to pay Jack, a $50,000 bonus and he's earned it. And normally I would, you know, maybe I would accrue that, and pay it in January or February. Once I received, the money from the sales that Jack made. But if I go ahead and pay it ahead, that's now part of the retirement plan formula. So if I look at that and I say, oh crap, that means this year I'm going to have to put another 15 grand into Jack's retirement. Maybe I'm unwilling to do that, So like that's why determining what I want to fund before the end of the year, even though technically the money's not due until later. And even though, a lot of retirement plans will say, well, we're going to need your final payroll data to be able to tell you what you can do. It's like, that's a bunch of BS, like they can, you can get like, I want to do all that really means like, right now, what I need to be deciding is, do I want to do 100 grand or do I want to do $125,000? Any retirement planning company can tell you what you need to do to get in the general ballpark. What they're talking about is, okay, based on the final answer, Jack, the number is $124,000, 387 and 5 cents. You're right. I mean, technically, I needed the final result to tell you that number, but that's close enough to 125 grand that I got it. Like I know. Like what I need to know is like, do I need at this point? I need to know, do I need to run a payroll for 50 grand more or not? Not like I need to accrue, an extra $300 instead of 500. So retirement plan calculations really important because it's going to impact your final payroll of the year.
All right. I'm up.
Yep.
Okay.
What did ChatGPT say? No,
Don't tell my secrets. No. It's funny because I assume if I were to do a ChatGPT search on things that this would be, I hope would be in the list. So I want to talk about technology and I want to talk
Hey, actually, so ChatGPT legal version, does it say it depends and I can't make the decision for you. And, like, I'm just kidding.
I think that's all in the user agreement that you click on before you're allowed to use it. So
Yeah,
yes.
because the accounting version says you're not recording this, are you? I'm just kidding.
Um, all right. So technology. And the reason why this comes up is because your documents that you are using with your customers, the documents that you are receiving from your customers, if you're using their documents, from your suppliers, from, in relation to all those things, likely have discussion about technology and your requirements. Even more so if you're processing data, meaning payment data and those kind of things. And so my suggestion is that you take a look at those because for two main reasons. First, a lot of times those provisions are on the backside of the document or on page 2 or page 10, and they're in the boilerplate. And sometimes if they're on the backside and it's a dual column piece of paper and it's buried in there in like 6-point font. And so, and it changes over the course of time. So the version that came out maybe in January of this year is different than the version you might see in December of this year. So a lot of times it evolves over the course of time. Because we've been in the electronic age for so long, many times it'll have some provisions and then it'll say it will incorporate by reference the terms and conditions that are contained at some website in cyberspace that one of the contracting parties controls. And by you signing off on that agreement or accepting those goods, you are accepting those terms and conditions. And so, for example, if you are agreeing to their terms and conditions in relation to processing payments that are made to you, and has a provision in there that you are responsible for any and all damages, consequential damages that they incur because of your failure to safeguard certain information that is in your database. So take a look at those contracts and see what it says about technology, who is responsible, the assignment of risk. One of the main reasons for a contract is to not only, well, put, who's who and who's doing what, but who is assuming certain risks. There's a line, and is it party A or party B? A commensurate with that is to look into your technology and what, should it have been upgrade? Was there an upgrade available that was available maybe in June of this year? Is there something else that you can do to fortify your system? Every once in a while, if you're an Apple, well, I'm an Apple user, iPhone user, I assume Android does the same thing. When the bad guys break into the next level of security, and then Apple has to come up with the next level of security. And the way they do that is they say, emergency update, download this, have this downloaded onto your phone tonight, or else suffer the consequences. And most of us comply blindly, or it does it automatically anyway, depending on your settings on your phone. But with what happens is that as this technology develops, there is an implied responsibility on all of us as business owners to, if it's available and it's reasonable to implement, it's not overly expensive, it's not unduly burdensome, that, and again, this is a Jack theory, try to enforce this in a court of law without having a contractual obligation. Good luck with that. But I'm just suggesting this as a good practice, is to make sure that your technology is up to date. When your software provider or anyone else that you're relying upon says, update this stuff and do this and do that, you need to do it. And subject to not being scammed, that make sure it's your actual service provider and all those things. But the consequences of not doing that is having someone come at you and say, everybody knew that there was this breach by this company that all of us use, and you should have downloaded or should have implemented this and you didn't. Well, why didn't we? Thought that was happening automatically. Well, for some reason it's not. So, it's incumbent upon all of us to not bury our heads in the sand. And not that we're doing it purposefully. It's just, we're all busy and we assume that when we hire someone to do this stuff that they're doing it and they're keeping us up to date and those kind of things. But, there is a duty upon all of us that are using this stuff to take a look and make sure that everything is updated every once in a while. And end of year, beginning of the next year is a good time to do that. Just to see if you didn't miss two updates that occurred earlier this year kind of thing. So that would be my first kind of just legal suggestion, things you might have missed, but also just a practical business thing that all of us should be doing.
Yeah. Cool. Thank you, Jack. I appreciate that. That definitely appeals to my love of details. That's quite ironic and said sarcastically. So
I heard the dun dun in my head. So
yeah,
all
yeah,
good.
yeah. There's a rim shot that went down there. Um, so on another one from the tax perspective, this goes without saying. Yet at the same time, I still get asked the question. Um, if I'm planning on deducting an expense, whether that's because I bought an asset and I want to depreciate it, or alternatively, um, I paid a bill and I'm a cash basis taxpayer, I actually have to do it. Like I can't and actually get it, in the case of a fixed asset. In other words, like I can't go down to the dealership on December 31st at 5 p.m. and say, I would like to order a fleet of F-150s that will be here in early February and get the deduction. You know, I have to actually have them. A lot of people, whether I pay cash for them or whether I finance, it doesn't matter. I actually have to have them. A lot of people, always ask a question about, this would be the part where you want to stop the recording, Jack, turn off the Shoemaker compliance legal team for a second, or compliance team for a second. But a lot of people always ask the question, well, I mean, like, what does place and service mean? I mean, like, I didn't drive it yet. you know, Yeah, I wouldn't get as hung up on that, because it's not like the IRS comes in and says, well, I'd like to see what miles went on the truck, as well as I'm going to expect to see that you geofenced it, and had it located on your premise versus, still getting washed at the dealership. That's probably less concerning as, you know, it's actually in your geographic proximity, or where I can make a case for it's in your geographic proximity. A lot of we've got a few clients that are fortunate enough that their tax problems are solved by corporate jet purchases. That's always one of my favorite ones. When I get to tell somebody, dude, you're making corporate jet money now. Like that's, you might want to consider that, as an option if you ever were into private aviation. That's a scenario where it's like, look, as long as you've bought the jet, have taken a test flight on it, and now it's in the shop getting some repairs, it's technically placed in service, versus like I placed the order and never got it. Another one that we get asked um, a lot. Yeah, that's the basics. I needed to have actually bought it, but at the same time, what's another one that we get asked about related to air travel is I bought a black card through JetPool, if that's even what they're called anymore, which is basically I prepaid for a bunch of flight hours. That's a tax deduction, even if you haven't taken the flight hours. But you actually need to have made the purchase, before the end of the year. So again, it goes without saying, um, you need to have bought the thing and actually taken delivery, even if delivery doesn't mean, literally in your driveway. It's at least close enough that I can make a case I took delivery by the end of the year. Not I ordered it and it's still on the boat from China. You know, I bought it. Well, you know, well, technically, if it's freight on board, that's getting into mechanics. You guys get my point. But invariably, like I'm going to get a call, you know, on December 31st, emergency. You know, do I need to blah, blah, blah? You know, so anyway, you got to buy the stuff. You got to actually spend the money, even if it's because you took out debt to spend the money.
All right. So let's talk about some more contract terms, whether you are the uh, provider of services or the recipient of services or goods, etc. So you need to take a look at the provisions in your agreements that deal with inventory, supply chain management, those kind of things. And in light of potential increased tariffs and disruptions to normal supply chains potentially. So if you are the one that is the assertive one that is providing goods and services, what are your outs if something were to happen and it not be a breach of your agreement for not providing the goods and services on a timely basis? So basically taking a look potentially at your force majeure clauses or similar clauses in there that give you a little bit of leeway in case things that are out of your control happen. Similarly, if you're on the other side of things, that if you are the recipient of goods and services that then are incorporated in what your output is, what are the outs for the incoming, your supply chain essentially for goods and services that are coming in that gets, their get out of jail free cards or their ability to say, yeah, and that might otherwise be a breach of the agreement, but not our fault. So it's a force majeure kind of thing. I would say that force majeure clauses over since the pandemic have been modified significantly to deal with things that are pandemic epidemic. The inherent nature of a force majeure clause, though, is that it is something unforeseen happening. There are arguments or people on both sides of is the next epidemic pandemic truly a force majeure event, in that we now know that it's possible. We now know what the potential impacts are if that happens. And we've also made strides in trying to prevent such an event by having vaccines. So you need to be aware of those things, again, whether you are the recipient of or the provider of goods and services in your agreements to see if, and again, those are just words, they're in a contract, right? And so they would have to be enforced against you, or you would have to enforce them to say, yeah, hey, this is a force majeure event. Relatedly, and I probably should say this for the next one, so I'm kind of combining two together. There are certain
That's
provisions.
okay. That's okay because I don't have any more.
Oh God.
So yeah, I was like, we're gonna cut early, or you keep on riffing, buddy.
Okay. Well, I got another one after this too, so I got at least
All
two
right.
more. All right. So
Yeah.
relatedly, in your contract, you may have seen this provision that says neither party may receive consequential substantives, all kinds of words for damages that happen after the fact that are not related directly to what the problem is. So, for example, a good example is lost profit. Okay. And so it's been many times deemed speculative, but there is the provision in there that says neither party is responsible for that. So again, if you are the recipient of goods and services, and because you didn't receive those, you could not generate whatever it is, your output, that, and you anticipated that that cost you $500,000 in lost profit. Okay. That's going to be difficult to get from the party that breached the contract for a number of reasons. But imagine the scenario that who's to say it's $500,000 in profit? What happens if you don't get paid? What happens if you don't have as many customers? What happens if those things sit on a shelf for longer than you anticipated, even though you're basing that number based on historical information? So be aware of those things in your contract. Let's talk about your employees and the contracts that you have with them, whether it is an actual contract that says employment agreement, or if it is maybe a little more not as clearly documented, that you have maybe an offer letter, you have a one pager with bullet points that says, we're hiring you, here's your salary, here's your duties. And then you refer back to an employee manual for all the other terms and conditions related to the employment. And so sometimes the information in the employee manual becomes stale, becomes is not how you're rolling in the company, that has been modified over the course of time, and people just do it just because that's how they're trained. And even though the employee manual doesn't quite say that, or says something differently, or maybe even the opposite of what the training is. And so end of year, beginning of new year is a good time to go back and look at your employment agreements to make sure that, and I'm not talking about necessarily things like the restrictive covenants and non-competes, which is also good to take a look at and make sure that it's relevant. So for example, if the geography that's defined in there was defined 3 years ago, and you've grown, and this specific person is responsible for, let's say it was just North Carolina, and now you've expanded to South Carolina, but the non-compete doesn't cover South Carolina, you may want to rewrite that to include South Carolina. Now, you can't just shove an employment agreement. I'm going way off on a lot of tangents today, so you may have to rewind the tape to really absorb all of this. But you cannot say, Happy New Year, here's your new employment contract. By the way, it includes South Carolina now, without additional consideration. Maintaining or keeping your job is not sufficient consideration. So there are ways to deal with that, whether it's a bonus that is not tied to a performance bonus, it's a separate bonus that is the employees made aware of the fact that that is in consideration of the increase in geography of your non-compete. So should take a look at that. But what I'm really talking about is things in the agreement that talk about duties. So if you say, okay, this is a breach of the arrangement, the agreement, because you didn't do what you're supposed to do according to your duties, but it's not listed in the Exhibit A of the duties list, you may consider modifying the duties and job description, essentially, of that job potentially, which doesn't need additional consideration necessarily. If you're adding on to the job duties, you probably need to pay them a little bit more, maybe. Or let's say it's just something different. Let's say they move into a different department, or they have different duties, or you've taken some of those duties away. More so if you've increased their duties, you need to add that. But just, my point in all of this is that we enter into agreements, and then we put them in a file in a filing cabinet, or we scan them, or we DocuSign them and put them on our computer, and then we kind of forget about them. So doing an audit of the documents that are essential to your business, again, supply side, demand side, internally with your employees, and taking a good look at what they say, and making sure that there doesn't need to be any modifications to them in the new year, to at least accurately identify and recite what the actual arrangement is. So in most cases, you're fine. So I'm not trying to create, panic that you need to now go open up that either metal file cabinet or electronic file cabinet and, scour through everything, but because your contracts internally. So just take another look at them. Now's a good time to do it, because once you go into the new year, you're gonna keep rolling and rolling. Yes, sir.
Cool. Couple follow-up questions on that, Jack. Just for my own clarification. Consideration for a non-compete agreement. You hear like different, give them $50, give them $100, give them $500. Like, I know there's no right answer, but is there sort of a practical um, practical guideline, whether it's relative to somebody's salary or whatever, like um, what's a practical consideration for signing a non-compete that actually is practical consideration?
The typical standard is a 2-night stay at the JW Marriott in Uptown Charlotte, the cost of that. So I'm obviously being facetious. So there is no the law says, adequate, sufficient consideration. And I'm not aware of a court case that has said what that actually means. I think what we think it means and how we behave with that is that it is, not nominal. So it's not $1, it's not $5, it's not $10. A lot of times I will say, okay, what is the normal bonus that if you're going to give a bonus, and take a percentage of that. Don't take a percentage cut out of it. So let's say if it was a 5K bonus, don't now say that, okay, $4,500 is for the performance bonus and now $500 is for the non-compete. It should still be $5,000 if that's the bonus that they're entitled to. But you might say, okay, an additional $500. Okay, so 10% for doing that. I'm not suggesting, and I don't think anybody knows actually what Clark Griswold's bonus was, but apparently 20% add on to his bonus was pretty significant as he was fainting. Do you know the actual number?
I don't.
Okay.
So that is pretty funny. Enough to do the down payment on the pool. Yeah. So then I guess second question related to non-competes, when you're talking about adequate consideration, job duties and all that kind of stuff, it's like how how has the how I mean, so North Carolina is an at-will state, right? And at the same time, I've got somebody that's got a non-compete. So it's like, you know, Jack, you're performing well, blah, 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 blah. I just feel threatened by you and I didn't like the cut of your jib. You're fired, or alternatively, even worse, you know, business kind of sucks. I've got to cut some labor. You're fired. So really, through no fault of Jack's, he just got canned. And now
Mhm.
he's bound by this non-compete. How do courts generally view the conditions of the separation in context of that? Because I mean, it's
Yeah,
just not sound like a socialist, but kind of seems unfair. You like I'm the one that made the decision because of my douchiness.
right.
Yeah.
Well, you already know the first two words that are going to come out of my mouth next, right?
Oh yeah, Chat
It
GPT. It
depends.
depends. Yeah.
Yeah. And so, and it really does in all seriousness that, what was this person doing? Are they management? Are they, inline, workers, and a whole lot of other factors, including the fact that they were terminated without cause, and now you're trying to enforce this. So then you get in on the one side, is it retaliatory for something? If it's a cut in labor, then the premise of a restrictive covenant is that the business that is enforcing it or implementing it has a legitimate business interest in the restriction. So things like, well, we don't want him learning our stuff and going next door and competing. We don't want her to take the relationships that, granted, she developed and she helped develop, but was flying our flag when she was doing it. And so those are legitimate business interests. When you start getting into, and then so, if there's a termination for cause, then it kind of all folds together that, okay, well, you entered into this agreement that had these conditions. If you didn't want to abide by these conditions, then you shouldn't have signed the agreement. But when you get into an involuntary termination, then it is, okay, well, even though it's at will, that, is it a legitimate business interest to enforce that because it was a reduction in workforce. And so you get into kind of some of the squishy stuff as to, okay, what are the facts and circumstances surrounding this? And is it that, okay, if this person were to go down the street and work for someone else, is there going to be economic damages associated with that? Meaning, is he or she going to take customers? Is he or she really going to impact the business? Because remember, and this is going way into the 30,000-foot level of just law stuff, which is you can have contract, you can have a breach of contract, you can have and 100% the other party's in the wrong, and you will win the day. You may get a piece of paper that says, hey, you win. If there's no economic damages, then what do you win? And so it would, when clients come to me, I sometimes have to have, as I'm sure you do, Adam, is that, okay, yeah, you're right, and I understand that you're upset, but at the end of the day, what damage has this person done? Well, blah, blah, blah. I said, okay, translate that into dollars. Translate that into something that a jury or a judge can understand, that cause and effect. The cause is that they are competing. The effect is that we lost $500,000 because of that, potentially. If there's no effect, then I'm happy to take your money and represent you and file a really nasty lawsuit, but understand that it's likely you're pursuing your principles and a matter of principle and potentially vengeance against this person, versus it being kind of something that you want to recover for damages. So it becomes an interesting conversation. And I tend to take baby steps with clients that are feeling that way, because many times, I shouldn't say many times, sometimes we get tens of thousands of dollars into litigation. And then there is, oh gosh, there is emotional, psychological, financial fatigue in moving forward with this stuff. So that's why that's a long-winded answer of saying that it depends on the circumstances. It depends on the person. It depends on the effects of the offense of competing.
Yeah. So then, I guess last question, unless your answer creates so many more questions for me, but this is always an area where we've seen clients get burned. So I will describe my exact scenario, which I didn't pursue anything with it. I'm just curious, because I was economically harmed, and I'm kind of wondering, would I've had a case or not, I've not had a case. So we have a non-solicitation, non-compete agreement. And the person voluntarily resigned, um, and started their own firm. So that's clearly going in direct competition with me, right? So they did not take a client during the duration of the agreement. Nobody left in the duration of the agreement. At the stroke of midnight, clients left because it was pretty clear that the person had been keeping in touch during the duration of the agreement. So, given that, but hey, we were not economically harmed during the duration of the agreement. So it kind of gets the solicit. It's like, how, at the same time, like, how many times, could you say, look, I mean, things have like multi-year sales cycles, like, hey, that just happened to be when the contract, no, it happened out of the blue. It's like, where, you know, I wouldn't think that I would have an enforceable claim, yet, people do that all the time. It's like, hey, I left, I can't work with you, but we're keeping in touch. Like, we're LinkedIn buddies. I'm sending you stuff, about the new company, but but you're, so I'm air quote soliciting you, but perhaps not in the strictest definition of solicitation versus the where sits where sits the law in a scenario like that?
Yeah, so that's tends to be a slippery situation because it could be that yes, there was contact during the restriction period while he or she was employed, after termination during the restriction period, the hands-off period, and um, the whole claim falls unless you have that former client that is willing to get that has your back, your now former client, and
Yeah,
right,
what are the odds of that? Yeah,
right, exactly,
Adam, you're fired. But if you want to take my new CPA to court and sue him, I totally will testify on your behalf.
right, exactly. And so, and
said
that's the
said no
problem,
former
right?
client ever.
Right, right. So, then it becomes how do you approve the solicitation or necessarily what came first and the reason for the change in service provider. So, and really all it takes is that client to say, well, I appreciate Adam's work but I really had the relationship with this person. I understood that he was under a non-compete. He told me about that. And yes, it was at 12:01 a.m. on the first day of his being let out of the purgatory of non-solicitation and non-competition that I went with him. Now, if that had happened during the restricted period, then you would go back. But again, it's you would likely depose this client, this former client, and then are they willing to lie under oath in a deposition in live testimony? And that's the problem, is that you have to have corroboration of the solicitation by by the solicited party who, again, unless they're loyal to you, or maybe, and this is unlikely too, like in fantasy world, your former client said, "Oh, I thought you guys had divvied up the pie, and you were okay with me going with him, and now I found out that he lied to me, so now I'm mad at him, so now I'm back with you, Adam." So again, unlikely for something like that to happen. So that becomes the problem with non-solicitation. The non-compete, either the person is competing or not competing, and if it is, you cannot do this work, depending on the non-compete, what the restrictions are, you can't do this work, or if it's hands off on clients, specific clients, and then that becomes in the gray area that you can't say any and all clients of BGW. It needs to be specifically tailored to clients that this person touched at some point while they were working for you. And I would tell you, many non-competes are not drafted specifically enough to prevent that situation, which is that it may be someone that they did work for on and off, or they were part of a team. And so that weakens the enforcement of the restrictive covenant.
Yeah, got it. All right, I'll shut up now.
No,
I
those are
mean,
all great questions.
kind of validating when I always felt it's like, yeah, I can have you sign this, but
Well, that's the thing. I mean, it does, clients
like
are not
I
happy
really
when I tell them, hey, yeah, well, but you drafted this agreement. And I said, yeah, but we also talked about the fact that, it takes money to enforce it. And then, you have to do a cost benefit analysis. Again,
yeah.
going to what is the impact of the business? And one of the first conversations I have, or discussions I have, is what is the effect of this person doing what they did or what you think they did? Can you trace the dollar? Well, I don't know. I heard this. And so a lot of times, instead of launching a missile at this person, we end up launching a shot over the bow that says, "Hey, former employee, it's our understanding that you are now working for this competitor. We remind you of your obligations under this agreement." And then we also send a letter to the employer. And it's you have to do it right, in a sense that you don't want to now be accused of tortious interference of contract. You don't want to interfere with the contract of your former employee and their new employer to a point where it messes up the relationship, and in worst case gets them fired. So it is a letter to the employer that says, hey, by the way, you've employed one of our former employees. Just want to let you know that pursuant to his or her contract with us, there is a restrictive covenant for 2 years from termination date, which was X 2024. We assume that you will abide by those terms and conditions. And the letter to the actual former employee would have similar language. We assume that you have not violated the agreement, that you will not violate the agreement. For the employer, a former new employer, it is, we assume that you have not received any information from your new employee in violation of their duties and obligations to us to maintain confidentiality. Now, the problem with CPAs, with lawyers and doctors and other professional service providers is that there is this kind of implied concept that the customer, the client, the patient should be able to choose what service provider they go with. More particularly with physicians and attorneys, that the client and the customer gets to choose. They are not bound by handcuffs to a particular service provider. It's more implied in your industry, as far as I know, unless you tell me no, there is an ethical standard that says that, okay, we cannot necessarily force a client to stay with us. I mean, it's just a general concept, and you would not do that anyway. I mean, when the relationship is poisoned for whatever reason or has changed, you don't necessarily want to stay with that client, so long as the client has the proper information, that you didn't abandon them, that you don't have an arrangement with the person that is now doing their work, that you weren't thrown under the bus, that, okay, let me tell you that you were overbilled, and I want to say something about it, but come with me and your rates will be half, kind of thing. So none of that stuff. So it's just the way the market runs.
Cool. All right. Well, we're at 11:52. You got another one, or we could open it for questions, or you want to save your powder for the next round?
I think I'm going to save the other things that I have will probably take more than a few minutes that I get
Okay.
into, and will probably generate questions. So it's probably a good stopping point. But if there's anything that's on anyone's minds in the audience that they're addressing in this moment in their businesses, or have some questions, whether it's legal, accounting, otherwise, college football, whatever it may be. So happy to share Jack's opinion and Adam's opinion of that.
Yeah. Hey, side note, I was happy to see Arizona State win the championship game. That's my alma mater. It's only been since 1996 that they actually won anything. So I'm kind of curious to see where they get to in the playoffs.
So I'm curious, and maybe, if anyone wants to answer this anonymously, like, has anybody really gotten into the whole betting arena with college sports, and especially in North Carolina now that it's been legalized? And I don't gamble just because I don't like to gamble the money that I work hard for. But there's also, okay, I have no problem with a stocking stuffer of going and buying a bunch of scratch offs and put it in my kids' stockings from Santa, because they tell me they still believe in Santa. So gotta make sure that Santa delivers on Christmas Day.
Yeah. Yeah. It's interesting. Yeah. We had a couple guys at work to do, but I'm with you. All
All
right,
right.
Steven, DraftKings, never bet a lot. There you go. Classic CPA move out of Steven.
There
Yeah.
was there was someone on TV that was talking, and someone asked them a question about betting, and it was like a hot potato. Like, he did not, I can't remember what it was. I heard it in the background. He's like, betting, I don't know what you're talking about. Why would you even bring that up? Because it was talking about betting on the game that he was in. It may have been
Yeah.
on college something, but I mean, they were joking, obviously, but he just was like, okay, no way should I even use that word out in public, let alone on national television. So
Yeah.
just
I will
interesting.
I will I will share a funny side story. I guess it would technically be betting, but not betting in the classic sense. There is a quarterback who was drafted that is in a fantasy league with some of his friends who did not draft himself. So, I thought that was pretty funny.
That is funny. Yeah, that would be very yeah, it would be
Who happens to be playing pretty well right now. You can probably guess who it might be, Jack.
that's funny. Good,
Yeah,
good, good, good.
yeah.
Yeah, that
So
can be problematic. So anyway, all right. Well, I'm good to go. We got you guys out of here on time. Got you have a few minutes back in your day.
yep. All
So
right, landed the plane. We'll see you guys again soon.
thank you. Have a good rest of the week.
All right, see you guys.
Bye.
Bye.